My introduction. My name is Ajit Mishra. I'm partner with a European law firm called GM Brony, and I'm international head for the firm. I'm also chair for CCLS India, and that's the reason I'm over here. CCLS India, that was launched in 2020, November 26th, and I'm very sure a few of you were there as part of the launch. Since we have launched, we did series of events which has attracted some of the prominent lawyers, judges, QCs, and to keep up that tradition, today we have got Gourab. Gourab Banerjee, he is one of the prominent lawyers, most prominent lawyers in India. He graduated first class honors from Cambridge University. Gourab has developed his practice mainly before Supreme Court of India as a senior counsel, and with an emphasis on commercial law, commercial matters, and commercial arbitration. Gourab is also overseas associate of Essex Court Chamber, which is one of the prominent chambers in the UK. Today, Gourab has taken out time and he's with us to share his knowledge and a presentation about cases that shaped arbitration landscape in India. So over to you, Gourab.
Thank you so much. Thank you. I'm really happy to be here, and particularly happy that this is at least to some extent a physical event rather than all virtual. I did a 12-week lecture series in Jindal only virtually, and it was very, very difficult. So I mean, I'm really happy that at least I can speak to some of you here. This is a topic which is obviously difficult in the sense of how do you choose, say, arbitrarily 10 cases which make a difference, and if you choose 10 cases, obviously you leave out 10 other cases. So what is the criterion on the basis of which I have chosen these cases? Essentially, those cases which don't really state the law, those cases which are a little controversial, those cases which bring out new concepts. So I've just chosen 10 arbitrary cases, essentially is the reason I've done this. Anyway, so what is the context of this? I'm not going to take you back into history. The context is, I'm sure all of you know, the Arbitration and Conciliation Act came in 1996 in India. It came in through an ordinance. There was a bit of controversy there, but that is for another day. 25 years on, 25 plus years on, there have been a number of amendments. You also know about those, 2015, 19, and 21. And so obviously some of the jurisprudence has evolved, but yet there are many, many gray areas, and we'll of course talk about that later. So let's move on to the first slide. So this is a very interesting gentleman, Jan Poulsen. I'm doing an arbitration in front of him. He's one of the arbitrators, the Amazon arbitration. And his comment is that the courts of India have revealed an alarming propensity to exercise authority in a manner contrary to the legitimate expectations of the international community. So this was the view of no less a person than Jan Poulsen. Maybe this is a comment he made maybe 20 years ago. So 20 years ago, we were really not highly respected in the arbitration world, and a lot of such very eminent arbitrators used to make these sorts of comments. I wonder whether he'll make the same comment now. I'll ask him next time I meet him. Okay, this is a topic which I'm sure anybody who has done arbitration in India constantly is told about: public policy. So this is a quote from a judgment of 1824. It's a very unruly horse, and once you get astride it, you never know where it will carry you. It may lead you from sound law. This is constantly quoted in all cases regarding public policy. But what is very interesting and nobody really knows is, and I would request you to read this case for the purposes of entertainment. You can look up this case because it's a very interesting case. It's about the East India Company. It's about a ship which was chartered for 6 voyages to India. And the question that arose was whether the captaincy of the ship could be sold. So lucrative was it that the captaincy of the ship was sold to from A to B. And the question was whether it was contrary to public policy or not. So if you have a chance and you want to read and you have nothing better to do at 10 o'clock at night, you can read the judgment because it's actually quite entertaining, not for the law, but for the facts. Okay. So this is the first case I've chosen. I'm sure this is very, very familiar to many of you, but I'll tell you some interesting, shall we say, gossip about this. So this is ONGC saw pipes. You have to see the context of this. This is soon after the 96 Act had come in. The 96 Act was basically a copy, cut and paste of the model ancestral law on international commercial arbitration. So we simply copied a model law and we enacted it, and even there we made some tweaks. But the fact of it is that ancestral model law was designed not for purely domestic arbitration, but for international commercial arbitration. So when this case came up, it was a very, very simple case. Saw pipes had delayed supply to ONGC. ONGC had punished them by levying liquidated damages. The arbitral tribunal said, sorry, refund the money. There is no loss which has been caused to saw pipes. Those were the facts. Very, very pedestrian and simple case. And the general understanding was that because of the new law, then the new law under section 34, which was the model laws, article 34, that the challenge will be very limited and really very difficult to overturn this sort of award. So the lawyer who was appearing for ONGC was Mr. Ashok Desai, who many of you may have heard of, was the, I think he had just stepped down after being AG, and I was assisting him. And when the case was going on and we were not really going very far, so in a conference, I suggested to him that we should try out the concept of manifest disregard. It's an American concept. But on his feet, he coined this term of patent illegality. He just plucked it out of the air and he pushed it at MB Shah, and MB Shah took it up, and the rest is history. And we had a completely new head of patent illegality which dropped from the skies. And it created a massive backlash. And Mr. Fali Nariman, who according to me is probably the greatest arbitration law, I mean, there can't be much doubt about it, the greatest arbitration lawyer, at least that India has produced, apart from being one of the greatest ever. So this is what he said. Court has altered the entire roadmap of arbitration law, put the clock back to where we have started under the old 1940 Act. The 96 Act might as well be scrapped. Very harsh word. There was a learned article in LQR by Javed Gaya, Judicial Ambush of Arbitration in India. So everybody was up in arms. What are you doing? This is back to the old law. Very unfortunate, patent illegality. But, and this is the catch, this is 2003. 2015, pursuant to the Law Commission report, 246 Law Commission, I was also party to that, Justice A.P. Shah. This concept of patent illegality was introduced for domestic arbitration, purely domestic arbitration. Why? Because in India, and we have to understand our situation, you need to have a wider challenge for arbitration awards. Unlike in England, where if you move an application under 67, 68 of the English Act, almost inevitably it gets dismissed. So there's some disquiet about that. But in India, looking at the sort of awards that some arbitrators make, the policy was that you should have a patent illegality defense. And so I think Ashok Bhai, I mean, he's passed on, would be very happy to see that his concept has made it into the statute. So let me go on to the next case. Okay, this is SBP and Patel. So you'll see a judge, and then you'll see an administrator. And this is a very peculiar case, 7 judges. So that itself makes it very unusual. And the debate that was going on was whether an order under section 11 of the Arbitration Act was judicial or administrative. Now, this was, according to me, a very peculiar debate. Section 11 of the Arbitration Act is a very simple section. It tells you how to appoint an arbitrator. So you appoint an arbitrator by consent. If you can't, then the court will appoint it. That's all it says. It's a copy of the model law. The model law is there in any number of countries. The question is then, why is it only in India that you have so much law on Section 11? And I'll suggest an answer. But this case went from 3 judges to 5 judges to 7 judges within a matter of 5 to 7 within a matter of 2 weeks. And I was arguing the case on the losing side. And I remember this was one of the most hostile benches I faced. And Justice C.K. Thakkar, who gave the dissenting judgment, did not say a single word in the hearing. So at the end of about 1.5 hours, I mean, there was complete a wall of hostility, and they found, as many of you will remember, that this was Section 11 is a judicial order, meaning thereby that the judges will decide at the appointment stage whether a dispute is arbitrable, non-arbitrable, accord and satisfaction. Then you had the Bogara round, Justice Ravindran, 3 categories. Then again, there's an amendment of Section 11. 11(6)(a) has been brought in. We tried to restrict the scope of Section 11. Again, you have Vidya Drolia. So this is a mess. Section 11 jurisprudence in India is a mess. And I will suggest to you the reason is very simple. We copied the model law, but we did not even copy it properly. In the model law, under Section 16, which many of you may know, Section 16 is where you have a jurisdictional challenge before the arbitrator. So Section 11, you appoint AVC as arbitrator. Section 16, you go before him or her and say, well, you don't have jurisdiction, it's non-arbitrable, accordance, or whatever, limitation, whatever. In the model law, the arbitrator has to decide, and there's a full-fledged appeal to a court. But in India, I don't know why, I do know why, but I can't articulate it. We have a peculiar situation that the Section 16 appeal is only there if it is allowed. And if you lose your Section 16, then it gets footballed to the 34th stage. So what now happens is, instead of having some control at the Section 16 stage, the judge at Section 11 stage inevitably tries to put his or her hand into it and decide matters, despite the Vidya Drolia story, etc. I think it's a problem. I think it will continue to be a problem until and unless they amend the law and have a 16 appeal. I, in fact, wrote a letter to Justice A.P. Shah as ASG requesting him to put it in the 246 law report. He phoned me up and says, Gaurav, don't give judges any more powers. I don't agree with you. So you're the chairman, you will decide, but it's a problem. Anyway, let me move on to the next one. So this is the third case I've chosen, Balco versus Kaiser, authored by Justice Nijjar. The background to this case is that there were 2 earlier cases, both of which I'm sure you may have heard of. One is Bhatia International and Bulk Trading, where I was on the losing side, where essentially I was assisting Mr. B. Sen. The case was whether a foreign seated arbitration, in aid of a foreign seated arbitration, which was seated in Paris, could you get interim relief under Section 9, Article 9 of the model law? And again, we had not copied correctly from the model law. The model law provided Section 8, 9, 36, Article 8, 9, 36, 37, if I'm not mistaken, to have extraterritorial effect. We had, for God knows what reason, even not extended it. So 8 or 9 high courts, including Calcutta High Court, had held Section 9 jurisdiction cannot be extended to a foreign seated arbitration. Supreme Court reversed all that. Justice Variava basically told us, look, Mr. Sen and Mr. Banerjee, I'm very sorry. What I'm doing is I'm plugging the gap, and it's pro a foreign party, and therefore we extend Section 9 to foreign seated arbitration. So that was his justification. That's what he told us in court. That is how he interpreted the act. So that's the first judgment which was problematic.
The second judgment, in which this time, fortunately, I was on the winning side, extremely controversial, Venture Global. Venture Global versus Satya. The third round is still pending in the Supreme Court. I was on one side, Rohinton Nariman, then a lawyer, was on the other side. And we extended the Section 9 principle to Section 34. And we said, now you can, because it's Indian law, you can challenge a foreign award in, I believe it was Bangalore. And I remember coming out of court and Rohinton Nariman basically telling our side that, look, you messed up the law. And I remember saying, and I still remember saying, I told him that, Rohinton, you can correct it when you become a judge, which was a joke because this was 2008. Who was to know that he did become a judge, and the rest is history. Okay, so we move on to the next one. This is a, sorry, let's I just want to say one more thing, couple of more things about BALCO. So BALCO essentially holds that part 1 and part 2 are distinct. Part 1 applies to domestic arbitrations. Part 2 applies to New York Convention awards. And there's a difference between part 1 and part 2, overrules Venture Global, overrules Bhatia. But there's a catch here. In every one of these cases, there's a little catch. There's one paragraph in Bhatia, which is para 197. And it was authored by Justice Mishra, who was a barrister and a bencher of Middle Temple. And in this one paragraph, what he says is that I overrule prospectively, and only those agreements entered into after September 2012 will be governed by BALCO, and everything else is governed by Bhatia. So after 4 or 5 years, 3-4 years after he retired, I said, sir, why? Why have you done this? After writing such a nice judgment, which is so universally acclaimed by everybody, why have you put this? He said, I can now confess that had I not put this paragraph in, you would have had a dissent in this judgment. So this was a matter of compromise, as how judges work. Sadly, he is no more. In order to uphold and push through this judgment, that one paragraph was put in 197, which then had 2 regimes, and there was chaos. So one was the BALCO regime, one was the Bhatia regime. So you had all sorts of, but now, I mean, after 2012, so much time has gone by, that problem is over. Another interesting thing about BALCO is if you do investment treaty arbitration, you would have heard of White Industries. So the second case here in BALCO was White Industries versus Coal India. That was a connected case. Had this judgment come 2 years before it did, White Industries award would never have happened. That is the other interesting thing about BALCO. Let's move on to the next one. So this is Associate Builders DBA. This is not a case which lays down any fancy law, but the reason I have chosen this case is because this is a dictionary. So this judgment is a 2-judge bench judgment with Justice Nariman writing the judgment, sitting as the junior judge to Justice Gogoi. And this judgment is very interesting because just a little while ago, before this, there was a 3-judge bench of ONGC Western Gecko, which had all sorts of problems. And this was Justice Nariman's attempt to, as he put it, elucidate the law. So he curtailed the 3-judge bench by narrowing the language in this. So if you read this judgment, and then if you read this second judgment, Sanyong, if you read these 2 judgments, you don't need to read anything more about Section 34. So this is the second of the Section 34 judgments, Sanyong NHAI. And what is interesting about this is that the Supreme Court and Justice Nariman essentially explains the scope of Section 34. And this is an amazing judgment because it gives the history and geography of this. So he explains the 2015 amendment, he explains the concept of public policy, he goes to the pre-2015 position, he explains associate builders, all great. But it is an interesting case because at the end of the day, he sets aside the award. So after saying everything positive about not setting aside award, you read the last 10 paragraphs, he sets aside the award. not only does he set aside the award, he under 142, he makes the minority the majority award. And the logic which he gives is that the arbitral tribunal made a new contract for the parties and I set aside the award and I substitute it with the minority award. So I actually had a discussion with him on that. I said, you know, all this is great. How did you do this? He said, no, I just felt it was wrong. So that's the point. I mean, at the end of the day, the result here is slightly inconsistent with what is said in, but it's a judgment which, if you read two judgments, this one and the previous one, you don't need to read anything else. You know everything there is to know about 34. Okay, next. So this is the next judgment I've chosen, BCCI Kochi. So the background to BCCI Kochi is when the act came in 96, there was a judgment called Nalco Prestil of Justice Hegde, which propounded this theory that the moment you file a petition under 34, there's a stay of execution of the award, which essentially meant that all you needed to do to really sabotage the 96 Act was to simply file a 34, get notice issued, and sit on it for the next 10 years. So in order to get around that problem, the Law Commission, Justice A.P. Shah's Law Commission, suggested that there should be an amendment. That was accepted. 36(3) was brought in. And the idea now was and now is that you can't just by mere challenge get away with it. You'll have to ask for a stay, and if you have to ask for a stay, then you will have to deposit the money. That's broadly how it now works in court. But the issue which arose in this case was, what happens to all the court proceedings, all the 34 petitions which are pending? And we had argued that this amendment of 2015 is prospective. But Justice Nariman was of the view, no, under section 26, it applies, 26 of the 2015 Act also applies to pending proceedings in 34. I think it's a bit of a stretch, but that's what he held, and sour grapes, he held it against us. So I mean, the court is always right, but anyway, he held this. But then what happened was, and that is the most unusual part about this, is the government knew this was a problem because the government had some major awards which it had challenged prior to 2015, and all of them were pending in court. And had this interpretation of the law been correct or understood to be correct, a lot of the government's major awards, including, I think, Antrix, would have been open to challenge, in the sense the government would have to move a stay and get a stay and deposit, you know, whatever, 3,000, 4,000, 5,000 crores. So the government then decided to amend the act. And they came out with a press release. And I remember this press release being shown to the bench. And the judges and Justice Nariman went ballistic when he saw this press release. And he did something extraordinary. Normally, you decide the matter before you. Right at the end of this judgment in BCCI Kochi, he wrote 5 paragraphs, particularly paragraph 78, saying that the government will be well advised not to bring in this legislation because it's not in the interest of arbitration. I think it's very unusual for a judge to comment on a proposed piece of legislation, but he was very upset. And you have to realize that he was a junior of Mr. K.K. Venugopal, the AG. So he basically called the AG and told the AG that, you know, look, please don't do this. But of course, the AG being the AG and the government being the government, the stakes being very high, the amendment was carried out, which then resulted in this Hindustan Construction Company versus Union of India, an unusual case, Article 32 petition entertained before the Supreme Court. Arbitration Act provision struck down as being manifestly arbitrary, contrary to Article 14. I've never seen this in an arbitration case, but that's what was done in Hindustan Construction. I appeared in this Kishan Ganga arbitration. That's why I put this up, but that's a major project which HCC did. Basically, Justice Nariman struck down the amendment, restored status quo ante, brought back section 26 of the 2015 Act, obliterated section 87, and made some very, very harsh comments with the government, and restored Kochi, and overruled for good measure Nalco and Prestige, which was Justice Hegde's judgment. So this is now the law, which is good in the sense that now you can't simply just wake up and challenge an award. You have to put your money where your mouth is. So all the public sector undertakings now are forced to at least deposit some or all of the money in court. So I mean, the result was certainly pro-arbitration, but I think the government was not amused by the exploits of the Supreme Court. Okay. Right. So now we move on from part 1 to part 2 of the Act. And there are just 3 more cases to go. So as you may know, part 1 is domestic arbitration. Part 2 is the New York Convention, implementation of the New York Convention, sections 44 to 52. I have never seen a Geneva Convention case. And I think the last Geneva Convention case I've seen on the statute, on the judgment of the Geneva Convention, maybe 60s. And the reason is because of the New York Convention actually excludes, if you sign the New York Convention, you actually exclude the Geneva Convention as such. So this is one of the first New York Convention judgments. And I would say that this is an outstanding judgment. Rohenton Nariman calls it celebrated. A celebrated judgment which was given pride of place in Sanyong are his words. I would say this is a spectacular judgment. So to understand, it says 94 supplementary 1. This was argued in the Supreme Court in the summer of 93. And the legal teams on each side. So this was to do with a power plant called the Renukut thermal power plant. Renu Sagar was part of Hindalco. General Electric is General Electric, and they were setting up the plant. So Renu Sagar had in their lineup, some of these names, all of them you know, KKV, Mr. Venugopal leading, Abhishek Singhvi, Parag Tripathi, and Siku Mukhopadhyay, all now senior counsel. That was the team, the dream team. And on this side, Mr. Shanti Bhushan was there for us, and I was one of the juniors. And this was argued during the summer vacations. And the 3 judges on the bench were Justice Venkatachalaya, one of the great judges, and 2 barristers, Justice Anand and S.C. Agarwal. And S.C. Agarwal was pretty much a leftist, a left-leaning lawyer. He was a chamber colleague of the great R.K. Garg. So he was certainly left of center. And in the hearing, he gave us a really hard time. So 93, 2 years after liberalization, huge attack on the Indian judiciary by Jan Poulsen, etc., saying we are anti-arbitration, etc. S.C. Agarwal is leading the charge, hammering the US company. So we thought we've had it. 3-judge bench, S.C. Agarwal pronounces the judgment, makes us win on all counts. That's fine. But this is the first judgment in the world which tries to define the meaning of public policy. What is public policy? So in paragraph 66 of this judgment, S.C. Agarwal defines public policy to mean fundamental policy of Indian law, interests of India, justice or morality. 3 headings he formulates. It is now part of our law after the 246 Law Commission. The first one, fundamental policy of Indian law, still there. Interests of India was supposed to be too vague. They've dropped it. Justice or morality has been qualified by saying most basic notions of justice and morality. So what is interesting about this judgment is that he takes into account the international legal position. He emphasizes the pro-enforcement bias of the New York Convention. He rejects all the arguments on merits of Renu Sagar, and the award is enforced. This is Renu Sagar 2. There was an earlier Renu Sagar 1. But it is striking that this is the thing. This is a judgment like this had it been given last year or 5 years ago, fine. But to actually come out with this in 93, 94, in such a situation where just post 91 liberalization is extraordinary, and the formulation of the law by Justice S.C. Agarwal was remarkable. And considering the fact that he was so hostile in the hearing, the judgment is quite the opposite, reflects, the international position. So this is one of the big judgments, as Nariman describes it, celebrated. Okay, second last case. Sri Lal Mahal versus Progetto Grano Spa. Now, why have I chosen this one? So there's a background to this. This is also a part 2 case, New York Convention enforcement. There was an earlier judgment called Phul Chand Exports versus O Patriots, 2011-10 SEC 300. That was also enforcement of a foreign award. There are 2 judge bench had held that New York Convention section 48, same language as in section 34. So if ONGC and SAW pipes is valid for domestic, ONGC and SAW pipes should be valid for New York conventions also. So patent illegality is a defense to resist an award. That was the judgment in Phul Chand Export. When this case came up, taking the help of Phul Chand, Rohinton Nariman then as the lawyer argued, well, in Phul Chand you've held that ONGC SAW pipes applies, please apply it here also. 3-judge bench in Lal Mahal overrules 2-judge bench in Phul Chand. This was you see wheat, so it was a case regarding export of wheat and SGS certificate, and it's a GAFTA case. There were problems with that award. I know, I was there. The award was, GAFTA was not great, but anyway. So award was permitted to be enforced in India. Phul Chand was overruled, but what the best, and the reason I've chosen this case is that the judgment in Lal Mahal was given by R.M. Lodha, and the judgment in Phul Chand was given by R.M. Lodha. So this is, I think, possibly the only case, at least in Indian history, where the same gentleman has given a judgment, has the intellectual humility and honesty to come to the conclusion that what he did was wrong in the Supreme Court, and he overruled himself. I don't think of any other judgment, and that is to the credit of Justice Lodha, brilliant judge. But that's why I've chosen it. It is special that somebody can do it. A lot of judges, it's very difficult to persuade them that they are wrong. But he was persuaded that he was wrong, and he reversed himself. So that's why I've chosen this. And this is the last case, also very arbitrarily chosen. In 2020, there were a lot of cases in the Supreme Court. It was a bumper year for the New York Convention cases. There was Centro Trade. I had appeared in Centro Trade. There was Vedanta. I was the amicus in Vedanta. There was NAFED Alimenta, which has a lot of criticism in NAFED Alimenta. And then there was Vijay Karya Prasad. So this is a case which was an LCI arbitration under English law, and there were 4 awards. It was conducted by a friend of mine, who's the arbitrator, David Joseph, whose chambers you will find down the road on the first floor. His rooms are on the first floor, so in the Essex Court chamber. So David Joseph QC, 4 awards. The issue was for control of a company called Ravin Cables. It was a JV. The Italian company had 51%, the Indian partner had 49%. But as is usual, the Indian partner had managed to outmaneuver the Italian party, and they were out. Even with for 51%, they were out. But the final order was in favor of Prysmian and to buy out the Indian party at a reduced price. So anyway, that award was challenged. Bombay High Court said nothing doing. Matter came to Supreme Court. Again, I wouldn't say that any new law was declared, but it's another very, very impressive judgment by Justice Nariman, in the sense that entire history has been given. One bite of the cherry, Article 136 is not an appeal. He talks about Renu Sagar, he talks about Lal Mahal, he talks about Singapore judgment, he talks about US judgment in Parsons, then he goes into great detail. And the twist in the tale is, never before or since has it happened, 50 lakhs costs, which was quite an eye-watering amount by Indian terms, 50 lakhs cost. But we were all laughing because that's really not even the actual cost. Because on one side there was Abhishek Singhvi, on the other side there was Kapil Sibal. So I think 50 lakhs was a probably drop in the ocean. This is the last case, Vijay Karya. Again, if you want to understand anything about the New York Convention, this is the, if I had to pick one case, I'd pick this and not the various other cases where I had appeared. Vedanta is very interesting. So these are the 10 I've chosen. If I was to choose another one which might influence future law, I would say Vidya Drolia. But obviously, in the limited amount of time that you have, I've chosen these 10. So this gives you an idea of the journey of the Supreme Court, the 96 Act, other than Renu Sagar. And this is the question I now pose. Has the unruly horse been tamed? You saw the unruly horse. Has it been tamed? I would say to a large extent, yes. Do you have the NAFED element? This is a picture of Shah Jahan. You'll find it in the Metropolitan Museum. So this is a question, still an open question. Our judges still interfere in 34, the Delhi High Court, also in the Supreme Court. So still an open question. And thank you.
Now we have got who have connected us through a Zoom link.
Right.
So I'll ask my colleague Kishan.
Okay. Okay.
If somebody has got any questions, and
sure.
then the floor will be open for you to ask any questions.
Hi everybody. Hi Ajit. Am I audible to all of you?
Yeah, go ahead.
Thank you. Thank you, Gourab, for wonderful presentation and sparing time to talk to us. And thank you to all the members who are present. So I have got a question from Mr. Singh, Gurkaranbir Singh. He want to ask Gourab. My question is pertinent to the status of asymmetrical arbitration clauses in India. Since the law is not settled on this position, what Mr. Gourab Banerjee think of it with respect to international position?
So I'm well, the international position, such as it is conflicting. But so far as the Indian position is concerned, there are two cases which are now pending in the Supreme Court, where the clause says one party can invoke arbitration, and the other party has no right to invoke arbitration and has to go for a civil suit. Two such cases are pending. There is one judgment of the Delhi High Court, single judge, which says it is illegal, and he struck it down. But the division bench didn't even go into it. It decided on another point. But two such cases are pending, so we really don't know what the outcome will be. But according to me, I don't see any illegality in asymmetrical clause. If you have signed on to one, then it's part of party autonomy. If you've signed on to it and you've agreed to it, then you've agreed to it. That, at least that's my view. But some courts have some courts in different jurisdictions have taken different stands.
Thank you, Gourab. I have got another request from Manu Mishra. Can the speaker kindly share the thoughts he may have on India's non-compliance with adverse investor state arbitral awards?
Okay, very interesting, right? So, well, I would say that that's not strictly correct. The first major dispute which went to in investor treaty arbitration was Dabur, which was settled even before it came to an award. White Industries, I know for a fact, a petition was prepared to challenge White Industries award, and there are problems with that award in Singapore. But again, the government paid up. So at least in two cases, the government paid up without the benefit of a challenge. So far as Vodafone is concerned, it's been settled. So far as Ken and Vedanta are concerned, they are still alive. I would not say that there is a policy of disobeying awards. There's a policy of challenging awards in the seat, which is perfectly okay. Disobedience is where there's a final award which has been the subject matter of challenge, and then the government simply decides not to entertain and pay. So I mean, I really don't think there's anything really wrong with the government resisting enforcement or the government challenging an award. We haven't yet come to the position where the government has lost and thereafter not paid. If and when it comes to that, I don't know, because there are other issues like antrix, but that's another dynamic.
Thank you, Gourab. Before I hand over it back to Ajit, I just want to mention there are not many comments in the chat. The excellent presentation, and thanks to Gourab. And I'm sure a few of my colleagues will have some questions in person as well. So I'm handing it over back to Ajit.
Thanks, Mishra.
Somebody there has a question. You have a question. Hi.
Sir, I have a very interesting question with regard to arbitral award. What is the validity of an arbitration agreement prohibiting the parties to challenge the award in the court?
So that depends on there are various answers to that. That depends on which law governs the award, which is the substantive law of the possibly the substantive law of the arbitration agreement and the arbitral proceedings. So in England, for instance, you can contract out of certain challenges. In India, you can't. So you have these standard clauses in some of these ICC, etc. So the short answer is that it is, at least for India, it's contrary to public policy. So you tend to ignore those contractual agreements, and your 34 remedy is there. That doesn't mean the award is set aside. So it will then be open to you to challenge on whatever limited grounds you have. But the idea is that to the extent you can contract out of an obligation, you can. I mean, if the public policy of the country allows it, you can. You want to limit your appeal in this country, you can. In India, you can't. So it depends on the different laws of different countries and different seats.
It is always said that arbitration is less expensive than court litigation. So what is your actual comment on that?
So I don't say that. Nobody says that. Nobody says that. No, nobody says that anymore. I mean, those were the sorts of comments you would hear 30, 40, 50 years ago. I mean, the reality is that arbitration is at the higher end, very, very expensive. But I will say this, and this is important. In India, we have now got the fourth schedule. And the fourth schedule is extremely reasonable. You may have a 400-500 crore stake, and the fees of the arbitrator is 30 or 49 lakhs. And that is actually almost unworkable. So the fourth schedule, which is now being imposed by courts on many arbitrators, is actually a problem. Because if you reduce the fees to such a low level, many good arbitrators will refuse to be appointed. It's just happened. Some judge who recently retired was asked whether he do the arbitration. He said not in Schedule 4. So it's a problem. So to answer your question, it's not inexpensive. That's the short answer.
Mishra has appeared again, so I'm not very sure. Do you have a question? Anybody else?
Yeah, go ahead.
My name is Ajit. I was practicing back in India with Bari and Gandhi for about 2 years.
Right.
And I had also done this is a very narrow question, like stamp duty visa the arbitration. Actually, I have 2 questions.
Right.
My first question is, there is a clarity in section 11
Right.
on the existence of the validity of the arbitration agreement. To what extent can the court go into it? Because of the 2015 amendment.
Right.
There's overrules and all those.
Right.
Section 9, I find there is not such clarity. So, for example, if a party moves for urgent release under Section 9 of the court,
Right.
and the other party comes and says challenges the validity what in section 9, does it grant the interim relief or does it like stay in the hands of that?
So 9, you're saying that there's an unstamped agreement and section 9 has been moved.
For example, it's about any ground validity and existence.
So then you see, because it's a question of interim relief, what now happens if you look at that new judgment of ArcelorMittal, Indra Banerjee, ArcelorMittal SR Bulk, and appeared for ArcelorMittal, that essentially says because of the new amendment to 9(3), quite often, at least the Delhi High Court and various high courts just football it to the arbitrator. And then at the stage of interim relief, you can raise a ground of existence, etc. That will, a prima facie view will be taken. So for instance, I'm doing now an arbitration where it's a fight regarding Hero Electric. So, and one of the parties, for instance, is a listed company. They think we're not bound by the agreement. That's a point to be argued in the section 9 on a prima facie basis. They've taken no account. So that's how they're dealing with it.
I had another question, sir, regarding validity and existence of an arbitration. That does this in India. So Justice Nariman's judgment, Garware was out.
Right.
So that
So Garware is now gone to 5 judges
So Garware was later on upheld with
and gone to 5 judges now.
But sir, there was NN Grubel, which also was a coordinate bench of co-equal strength by
Correct.
Justice Chandrachud.
Correct.
So on this issue, where Vidya Dolia upholds the decision of Garware and says that
3 judges.
3 judges, correct, and Garware was 2 judges, Justice Nariman and another judge.
So now it has gone to 5. So Garware has gone to 5 because of this.
So I want to know your views on it.
So,
Not insufficient stamp duty or deficient.
So
stamp
there
duty
is a very peculiar judgment by Justice Ramana, which is one of his halfway house judgments, where he says that in section 11, if it's, I know it has gone to 5 judges, so I can't really decide this, but if it's in section 11, and if it is a case of no stamping, then I will not appoint. But if it's a case of insufficient stamping, I will appoint. So this is what he's done. But the short point is, according to me, Garware is wrong, because the question of stamping cannot, arbitration clause is separate from the underlying agreement. You should appoint an arbitrator. Garware is simply, I don't agree with the logic of Garware, but that's my view. I mean, God knows what Supreme Court will do. It's gone to 5 judges, so we'll see whenever it happens. Not happening anytime soon.
Why is all our business going to the CAC?
Why is all our business going to the CAC? There's a simple reason for that. I think there are a number of reasons. So first of all, they market better than anybody else in the world. So it's not your business that is going to CAC. It's London business which is also going to CAC. So they're quite upset about it. So they will never, ever, ever in any conference or in confidence ever say that their system is bad. But let me tell you, their system is bad in some ways. So they have, I remember going there in 2015 after the amendment, and we had introduced this 1.5 years time limit for award, and there was a lot of controversy here. And I had a lot of questions on that. And I was also party to that 246 Law Commission. And after the thing was over, an old Singaporean gentleman came up to me and said, "Sir, it's a very good move. We have a Chief Justice of Singapore who's not given an award for 3 years. So they also have their problems, but they will never tell you." So point 1, they market better. They are equally expensive. People go to Singapore, I think now, because they have little, they lack confidence. They no longer lack confidence so far as the arbitration process is concerned. Because 1.5 years, 2 years, it's over. They are worried that the award will get stuck in the court system. That's why they feel that they can get an award there and come back and enforce it under the New York Convention. Now, with this judgment that 2 Indian parties can arbitrate, so no problem. Well, it was there in the 2019 amendment, but we have not been able to push it through. And the reason is that we don't have, I don't know, without massive government backing, you cannot have a world-class institution. So you have MCIA, which is very good. You have BIAC, which is feeding because it's too much work. You've got this new place in Hyderabad. Justice Ellen Rao is in charge. I don't know how they've got something in Gift City in Ahmedabad, where allegedly the Prime Minister is interested in that. So you have, but you will have to throw a sufficient amount of money at it, and you'll have to get a lot of people involved. Only the government has the money to do it. I tried in Delhi. We talked to a lot of the law firms. It costs about 50-100 crores to set up a Maxwell Chambers. And none of the law firms are willing to put in that sort of money. And it's a losing proposition. You set up a Maxwell Chambers, you don't make any money out of it. It's just sort of, it's a loss. The gain is different. The gain is your hotel and your this and your all very difficult to quantify. So that's why people are going. But again, with Singapore, 90% of the Singapore work is low value. So the high value work is still in Delhi and Bombay and London and Singapore.
So whether an award can be set aside at the stage of execution, because I have gone through the judgment of Justice Baku, where our award was challenged and it was upheld by the DB also. The award was upheld, but subsequently in the execution petition, the judge told that there is no arbitration agreement and the award was set aside. So
I have not come across that judgment. I will confess my ignorance. I will go and have a read of it. But I would assume that he would not have set it aside. He might have said that the award is nullity because so at the stage of execution, if you can demonstrate that the initial decision was a nullity because of whatever complete utter lack of inherent jurisdiction, then you may succeed in your execution. Suppose I'll give you a case such as if it's a rent controlled property and you file a suit in a civil court and get a decree, that is an execution, you can say it's a nullity. So I don't know what the facts here was, so I can't tell you. So give me a judgment, I'll be happy to read it, try and make sense of it. But I mean, whatever it is, all I can say is that Justice Baku is a very good judge. So I'm sure I would say he's one of the best there is. So I'm sure that whatever he said is, I have the greatest of respect for him. He's really good.
Justice Nariman passed this judgment. The project director, National Highway.
Hakim, yeah.
Yes,
yeah.
you are advised. I just want to know your view on it.
So this is the exact debate that I was having, and I was doing the same matter before the CJI 2 weeks ago, and he had this question for me as to whether that judgment was the correct law, and if not, how to get around it. But I actually think that what Justice Nariman has said in Hakim is the correct law, and there's a conceptual point to it, which is very simple. So if you have an award, let me explain the judgment for people who don't know about the judgment. So if you have an award, there's no appeal against an award. So there's no appeal on the merits. You can't say that the award is right, wrong, this, that, appeal, modification, etc. Either you affirm the award or you use the phrase set aside. Set aside means annulment. That means the award never existed. There is no award. So it's a 0-100. Either 100 with all its mistakes. So the arbitrator has made mistakes of fact, arbitrator mistakes of law. If you can't interfere under 34, sorry. That's final and binding. Right or wrong, you've chosen your arbitrator, final. So that's 100 result. 0 result is denial of natural justice, contrary to public policy, whatever. Award is gone. If the award is gone, then it's status quo ante. So with status quo ante, it means you start your arbitration clock again. So there's no award, there's no dispute. You start again, there's no res judicata, you start again. In that event, what Justice Nariman said is that when you are in 34, you can only set aside. You can't modify. Now this is great, but this goes on the basis that you will have a 34 judgment in 6 months, and you will have a 37 judgment in 6 months, and you'll have a Supreme Court judgment another 6 months. So 1.5 to 2 years, it's all over. You go back to your arbitration. But it doesn't mean that after 10 years, then the clock is set back. So in 5 countries in the world, at least that I know of, and he's mentioned in Hakim, US, UK, Australia, I don't know the other 2, 5 he is mentioned in the judgment. Everywhere there is a provision that you can amend or you can modify, you can do it. So has to be a specific statutory provision. Or you use 142 like Sanyong. Why did he use 142 there? He knew what he was doing was wrong, but 142, because otherwise, again, logically, award is gone. Minority award is waste paper. You can't substitute like this. Use 142. So the answer is, and this is what I told the chief, which did not really please him. I said, the only way of doing it is to have a legislative amendment. So on that happy note, he adjourned the matter. So it has gone back. So I think Hakim is in principle right, but practically unworkable. And then a very important question arises. Supposing the arbitrators have got it horribly wrong, should not they cough up the fees? I have come across an award. Again, it's before Justice Bakru. He's no longer there. 3 Supreme Court judges retired. 2 of them have delivered the award. They've not even consulted the 3rd judge. They just signed it and delivered it. After it's signed and delivered, the 3rd judge says, well, where's the copy? I want to see what you've written. They say, we've discussed it with you. Deliver the award. Now, that's an obvious challenge. And that challenge will succeed. Should succeed. Because an award is an award of 3 judges. You can't do this. It's contrary to the language of 31 of the Act and 34. But then it's set aside. What happens to the 25 hearings that have been held? What happens to the lakhs which have been paid? That's another problem.
I think we're done with the questions, but thank you so much.
Right.
It was really good. Ishu, do you have anything? No.
Yes, we have got more
Very quick
questions.
one.
Please go ahead. Fire away.
Thank you, Gaurav. So I have got a question from Aishwarya. She says, without a doubt, arbitration is indeed the preferred choice for Indian parties. How attractive are international commercial courts in the Indian context? Further, in the enforceability, is the enforceability of judgments from such courts still a key consideration?
So to answer that, there is only one model of an international commercial court that has been tried up till now, which is the SICC. And the SICC, and that was a brainchild of Chief Justice Sundaresh Menon. And there are serious problems as to how that is to be enforced. We have that 44A of the CPC by which we enforce it. But I don't think the International Commercial Court model has been that successful even in Singapore. They tried very hard to push it. They pushed a few arbitration cases into the SICC. But it's not really taken off in the way that it was hoped to be. So I think the default is, at least if there's an international dispute, that the only option is arbitration. I think arbitration is not the future. I think mediation may be the future. But as of the present and at least the near future, it's all international commercial or now investment treaty arbitration.
Gourab, Raghavesh want to know your opinion on including or adding non-signatory parties to the arbitral proceedings.
I think that will take at least another session. I was in Amazon and we managed to rope in Future Retail. And if she wants to know more about it, I think all that you need to do today is to read the judgment of Justice Ramana, where he has referred the concept of group of companies doctrine to a larger bench. In the SAP matter, I was for SAP and we had a terrible case, and unfortunately that case came up there. We wanted to drag in, I was for Cox and Kings. We had a terrible case. We wanted to drag in SAP Germany, and frankly, it was a very tall task. And he just has written this long judgment criticizing this non-party addition, and it has gone to 5 judges. I don't know what's going to happen. I think as a concept of adding non-parties,
The best commentary on this is Gary Baum. He gives 5 or 6 reasons as when you add implied consent, assignment, agency, etc., etc. So it's a huge topic. But if you want to get an idea or a flavor of it, read the Cox and Kings chapter, 2022, just now, 3 weeks ago. Yes.
If time permits, I can ask maybe last question. It is from another user who says that the fees of arbitrator in India is very high. Who will
Okay,
regulate?
I come back to the fees. Please go ahead. So enforceability of interim orders, you see, we managed to. Yes, raffles. Yeah. So
Because we start ICAs outside, we get an interim injunction.
So interim orders is a problem. I mean, emergency awards is a problem, but we got around that in Amazon because it was a domestic arbitration. But short of an amendment to Section 9, the only remedy is to file a second Section 9 and get that interim order confirmed. That's the only way of doing it. That's what we are doing now, because you can't do it under 48. So you get an injunction from abroad and you bring it and you file a second Section 9, which you can, because now Section 9 is extraterritorial, and you enforce it through that method. I mean, that's the method we are now following. It really requires an amendment to the Act. But
actually also have a clause in the contract saying that for any injunctions are enforceable in India, so something like that, so that there is no.
But how will you enforce it without a statute? Parties may agree to the moon, but you'll have to have some methodology of enforcing it. So supposing you and I agree that I get an injunction in Singapore, and you agree that it will be enforceable in India, but I will still have to come to India.
The parties are free to approach Indian courts for any interim injunctions.
But that is already there. Now you can approach because Section 9 is now amended. So you can approach. Earlier, because of Bhatia, you could not approach. Now you can approach for a foreign seated arbitration. We've done it recently as well.
What I mean to say is when you already have an arbitration outside India.
So then you can write it in your. Yes, you can write it in. You're absolutely right. Yes, you should write it in your clause. Notwithstanding the arbitration, you will yet, yes, of course.
It's workable, right?
Yeah, it's workable. It's eminent. Yeah, of course it's workable. It's definitely workable. So on fees, again, one more session. Just wait for the judgment in ONGC by Justice Chandrachud. He's reserved judgment. It will come out in July. There are a lot of things, a lot of issues on fees of arbitrators, which will be concluded by that judgment. 3-judge bench, ONGC versus I don't know what it is. It's just been concluded, where he's taken note of this excessive fees. So we'll see what he does.
Mishra.
Somebody's gone off.
Hi, Ajit.
On fees.
Can you hear me?
Yes.
Thank you. So I have many questions, but if time permits, I can ask.
Go ahead. I mean, I have no problem. First time I'm asking questions and not being paid for it, but go ahead. Go ahead.
Why? Thank you, Gourab. Why India restrains Magic Circle firm to enter the legal industry in India?
So why does India restrain Magic Circle firms from entering? This is a question addressed really which requires to be addressed to the Bar Council. And the Bar Council has been resisting it for the longest time. I mean, I can go back 10 years. We tried to get law firms in. I think there is a sense that they will take away the work of some well-known law firms. That's why they resist. I mean, though the color which is given is, it's anti-national and all these foreigners entering, but half these law firms here have Indian citizens and people of Indian origin. So, and they're not going to go and appear in Ghaziabad District Court. So So I think that the reality is, if you want to, at least in arbitration, many people are flying in, flying out. So the law firms want to come in more for non-lit and presumably mergers, acquisitions, etc., etc. But I think that's a question better directed at the chairman of the Bar Council.
I mean, I think that's more about foreign laws rather than practicing Indian laws.
Yes, I want to mention that people from Peru, people from Brazil and Greece, and of course UK have joined us for this session. And I thank Gourab again on behalf of CCLS India Chapter, and I hand it back to Ajit, please.
Thank you so much, Mishra. Thank you so much. And thank you so much for taking out time being over here, making us more educated. So thank you. And you don't have any questions. So I will say before you leave, can we have a photograph with you, all of us?
Yeah, I think that's a good idea.
Photography. If you go on the website.
Are we done with this, or are we
Yes,
still
I think.
online? Right, we're still there. Thank you for joining.
Thank you, Mishra.
Thank you.